Much for that introduction, Mr. Njam. Now let's get to the questions, to the meat of our discussion today. Can you share a specific story where a company had a seemingly guilty employee, but the entire case crumbled in court simply because the first respondent mishandled the evidence?
Oh, yes. I love giving stories, and I can think of one immediately. This was a case which, and I've asked them for permission, by the way, just to give a story. I can say where it is. I won't be able to say which company it was. There's a company where there was a driver, and his job was to log in every day. Whenever they would put petrol, he would log in how much petrol he's put in and the mileage. And if there was anything wrong with the car, he would send that information through by email. Now, there was a problem. He complained via email to say, I believe there's a problem with the car. The car needs to be serviced. And this boss had a very bad habit. Well, we're going to come to the bad habits of the ways people destroy corporate evidence, but he had a habit of, and many of us do it, when you get in the morning, you want to quickly check your emails so that there's no unread messages. And what he would do is that he had put a setting on his computer where messages older than 15 or 30 days would automatically get deleted. Okay, so he wanted to have a clean inbox. So he kept on, the machine would automatically delete, and sometimes he would also delete those messages. Now, here was the problem. This driver would put petrol, full tank, and within 2 or 3 days, the full tank would be finished. Guess which town in Botswana he was working? He was working in Hansi. Hansi is a very small town. There's absolutely no way, unless you've driven out of Hansi, there's no way just driving within Hansi that you can finish a full tank in 2 days. There is no way, even if you are someone who loves going out at night. Hansi is a very small place. I think Klokweng is bigger than Hansi, to be honest, with all due respect to anyone who comes from that area. And so they started an investigation. The management really believed that, no, this driver must be stealing petrol. He must be siphoning out petrol from the car, because even the mileage of the car, this was the problem, the mileage of the car was not increasing. So there was no mileage to justify why a full tank of petrol is going, and they suspected that this man is stealing petrol. Now, because the supervisor of the fleet kept on reading his emails and not keeping those logs of when the driver is saying there's something wrong with the car and when those logs happened, when they started the case, we had a problem. There was an evidentiary burden, because the employer was saying, look, I've told the employer not once, not twice, not thrice, that there's something wrong with the car. And the employer says, no, he's never told me. All we have is these manual records to show that petrol is missing. He says, no, but I sent. The employer says, I never got a single email. You can already see where there was a problem. The corporate evidence of what was wrong with the car was getting deleted by this boss. And he didn't think that, you know what, I need to keep, if it's electronic evidence, I need to keep all evidence. Deleting it is actually a problem. And a simple case which could have been proved on the evidence, or on whether there was actually a problem with the car or whether the petrol was being siphoned, couldn't be solved. It got even worse. The video, there was where the fleets were being parked, there was a camera which was recording everything that was happening, security footage. Again, the hard drive had setting. This is the same officer. The hard drive had the setting. It would record the whole night. And then instead of them looking at the activity before deleting and cleaning the hard drive, unless an incident had happened, they would just clean the hard drive and delete. What was happening? Evidence was going. This employee was actually selling or siphoning petrol right there at night. But because there was no thief who had come onto the place, this evidence was being tampered and lost. Very, very sad case. And I thought I would share that one with you just as a teaser of some of the mistakes, the common mistakes that people make and tamper with corporate evidence. Now, before I hand back to you, Sarangwaila, we need to just lay a little foundation, because when we say evidence, people in their mind immediately think exhibits. And the difference between exhibits and the word evidence. What do we mean by the word evidence? So this is a webinar. So Mr. Ramkwale is going to share the video, but very, very quickly, if you've got a pen and paper, you can write this down. Evidence is anything which can be used to persuade a court of the truth, and truth, put it in Ditsejuan. You see, even we've come from Easter. Even Jesus himself, when he was before Pontius Pilate, Jesus tells Pontius Pilate, I'm here because I'm the truth. And Pontius Pilate says, what is truth? Now, this is a question which the courts have grappled with over and over. What is truth? And if you think about it long enough, the only way to know the truth is to use a time machine. Time machines are things which we use on science fiction and in the movies. We don't have time machines. So evidence is what we use to establish what has happened before. In other words, evidence is a reconstruction of events. So in the search for truth, especially in our legal system, which is an adversarial system, you are trying to reconstruct brick by brick what has happened. And so truth is actually a reconstruction of evidence which has been gathered. And what happens in a court case is that the person with the best construction, the construction which is unshakable, even if you try and test it, it remains standing, then that person wins the case. This means that we've got different types of evidence. We can have like circumstantial evidence. We can have like real evidence. We can have even documentary evidence. And so with the different types of evidence, you have to be very, very careful how you store the evidence, how, when you're investigating, how you handle that evidence, especially if what you have is circumstantial evidence. You have to be very, very careful how you keep it, how you store it. If it's electronic evidence, how do you present that in court? Now, in Botswana and in the rest of the world, the Commonwealth countries, there is a very specific rule. That rule is called the best evidence rule. Now, what is the best evidence rule? Okay, now remember, evidence, I've told you, is things used to persuade the court. Evidence can also refer to the rules on how exhibits are brought into court. So evidence is two things: something which you use to persuade the court, and then it secondly refers to the rules that are used. And a good lawyer knows those rules. The reason why you're here is we're going to have a look at some of the rules that are used so that you don't tamper with corporate evidence again. And if you join the Rankuke Institute, we've got a whole course where we talk about some of these things. Now, the best evidence rule simply says that if there's the original of something, that is what needs to be brought to court. I'll give a crazy example. Some of us, including myself, have been charged with drunken driving before. Yes, so maybe you are at a party or something, and you are driving home from that party, and an officer stops you, and he smells alcohol on your breath, and he says, I think I'm going to take you to the police station. We need to see if you're drunk or not. Most people don't know this, but before they breathalyze you, they're supposed to show you something known as a calibration certificate to say that the machine is working. And if they find that you've gone above the limit, when they bring you to court, they need to bring the actual original affidavit, the person who calibrated the machine. If they bring a photocopy, you are well within your rights to say, nope, I don't want a photocopy of that affidavit. Where is the original affidavit? And every magistrate will listen to you and say, will tell the prosecutor, Ma, can you bring that original certificate? Can you bring the best evidence that you have? Same goes for the receipt printout. They're not supposed to bring a photocopy. Where is the actual receipt which was taken at the time that you were arrested? Where is it? It's called the best evidence rule. And one way in which people are tampering with corporate evidence is they are violating the best evidence rule. There's problem with the chain of the evidence. Who kept it, who got it the first time, who was it given to? There should be an explanation of the chain of evidence. How did it move? Who was holding it? If there's tampering in that chain, then whatever exhibit you bring into court is not the best evidence. It could be tampered with. We now no longer can finish the case without having doubt. Remember, there are different standards of proof. It's a criminal case, it's beyond reasonable doubt. It's a civil case, it's proven a balance of probabilities. If we are doubting the exhibit which has come, we can no longer balance the probabilities. So, by way of introduction, that's a small story that has had, and I had to lay that small foundation so that going forward, because I'm seeing some people here who do know a little bit about the law, and there are some who probably in a group like this who have never heard of anything like this before. So that's why I took my time to put that foundation.
Thank you very much, Mr. Mjama. I promise you that whole introduction, I have learned so much: circumstantial evidence, best evidence rule, chain of evidence, and we're going to get into it. And I also have a question about the example that you gave.
Oh, sure.
About
Yes.
the driver and Hansi, and I'll get back
Yes.
to it just now. But before I go to that question, I want you to clarify this for me. You had said that there's a difference between, I think you said annexure and evidence.
Oh, exhibit.
And then you explained evidence. I don't know if you have touched on annexure and how do we differentiate the two?
Okay, there we go. There we go. Now, I said there's exhibit and evidence, but I'll also tell you what an annexure is. An annexure is normally
exhibit. Sorry, yes, exhibit.
Yes, but an annexure is normally a photocopy of the real item which is attached to an affidavit. One other way in which you can give evidence is through by way of affidavit. Now, an affidavit is a sworn statement. Okay, so if you're not going to give oral testimony in court, if you want a little bit of Latin, I believe our politicians these days are even giving Latin in parliament. We call it viva voce evidence. That's living voice. Viva means living, voce is voice. So if you leave the webinar today, you can say, I know viva voce. That's rather more Latin, more than what other people know. If you're not going to give oral testimony, then the other way in which you're going to give your testimony is written testimony by way of affidavit. For example, in a maintenance case, let's say there's a man who has had a child with this woman, and he's not maintaining the child. And of course, the woman has run to court to say, I need my child to be supported. What's going to happen is that the man will give evidence of his means by way of affidavit. He's going to take a photocopy of his payslip, and that payslip will be an annexure. So he's going to say, I earn 5,000 pula, for example. I annex a copy of my payslip. I also annex a copy of my bank statement. So you can see 5,000, which I've told you, going to my bank statement. Then he will say, you can see from my bank statement that apart from my salary, I get nothing else. I only get that 5,000. And then, of course, you'll have to explain. The 1,000 you see coming in, this was a loan from a friend of mine or whatever it is. So what do you mean by annexures? But even then, the best evidence rules apply. So if you're on the other side and you go through these annexes and you see that this photocopy doesn't look genuine, this photocopy looks tampered with, can you come to court and say, you is looking at just the face of the annexure, this document doesn't look like it's the authentic one. Can I have the real one? Can he present the real one? And the court will listen to you. So coming back again to what we are saying here, if you are a corporate company and you're going to be giving evidence by way of annexure, make a good, true copy. Make sure you certify. A good officer has got good certified copies of their items. So at least whatever you are annexing to the affidavit is already a commissioned affidavit. And then here's a free trick because the police don't do this. Please, if you are in the corporate setting, have one of these stamps. Okay, it's a cheap stamp to make, and there are no legal requirements to have it. The stamp simply says this. This is the annexure referred to in the affidavit. Because most corporate people, when they do affidavits, they go and stamp at the police. And the police will just go to the last page. This is an affidavit. Where are you signing? Sign aha. Then they make you sign. They don't have time to write on every annexure that this is the annexure referred to in the affidavit. If you don't do that, it is not going to be accepted in court. And most companies now are doing business internationally. Most businesses are doing business online. We are doing business across our borders with China and other countries out there. If you're going to have a case where maybe your item didn't come, where maybe the item which came is not what you ordered, and you're using an affidavit, because now we've got international bodies which can hear these international trade disputes. If you don't have that stamp which says this is the annexure referred to in the affidavit, you will lose the case. So I strongly advise, please, 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 if you're in the corporate sphere, just have that stamp. This is the annexure referred to in the affidavit. When you come from the police doing your affidavit, some of the attorneys in town are also lazy. They will sign. They don't have that stamp themselves. They'll say, they'll write by hand. If they've forgotten to write by hand, it's useful if you have that stamp so that even before you go to sign the police, you've already stamped. This is the annexure referred to in the affidavit. This is the annexure referred to in the affidavit. So an annexure is a paper which is put in an affidavit. An exhibit refers to physical evidence. When we use the word exhibit, we're referring to something which you can use your five senses on. Remember from primary school, our five senses are hearing, seeing, touching, feeling, smelling. So an exhibit is something which you can use your five senses on and tell the court, this is the evidence I'm referring to. Can it be admitted as Exhibit A? So with physical evidence, unless you have actually tampered with it, there shouldn't be a problem. The problem comes, we're going to see in this webinar, with the other forms of evidence, being your electronic evidence, your circumstantial evidence, your documentary evidence. Back to you, Mr. Rankwaila.
Fascinating. Okay. I'm learning. All right. So
Thank
going
you.
back to the
I'm
example
happy.
that you gave about the driver in Hans,
Hansi.
I'm not
Yes.
sure if I understand what the case or what exactly happened here. The supervisor was deleting messages on the email.
On email.
And
Yes.
then I don't know if the supervisor was deleting messages on the email, but the recording can point to the individual selling a petrol there. Isn't the recording going to be admissible, or did they also
Oh,
delete the recording and stuff?
the recording was also going. The
Oh,
recording was
okay.
also going because of that setting which they had put.
Uh-huh. Okay.
So there was a problem there, and then I hadn't finished even the second part of the story. Now, with video evidence, you have to authenticate the video when you bring it to court. You need to be able to say that this is the machine we use. There is the timestamp on the machine. Every electronic evidence has got something which we call metadata. Don't worry, I'm not going to go deep into computer stuff. Metadata is simply data about data. So, for example, if you type something on Microsoft Word, without you realizing it, your laptop in the background, in the properties, will write who is the author. The author is the owner of the computer. What time did it start? When was it edited? Okay, now that's data about whatever you are typing. Okay, so when a video is being taken, in the properties section, there is metadata to say when was it recorded, by which machine, was it edited. If you save it onto a memory stick, there's metadata which says, okay, it was taken from this machine to that machine. The problem is this: if you put the setting that, and many companies do this, okay, their recording device is set to, because of hard drive space. Okay, I don't know why people are not buying cloud space. So because of hard drive space, many small companies, they can only keep the video maybe for 5 or 6 days. And the security company is supposed to sit, whoever is authenticating the video, supposed to sit before they delete, they're supposed to review the data. So you just play the video and hit record the movement. If there's nothing, it will look blank. Then you're supposed to rewind to see if there's something which happened, and then you save that portion of the video, and you save it on one drive, not many drives, one verifiable drive. And you should be able to come and say, I'm the one who edited that portion of the video. This company was not doing that. So, number one, there are emails which are disappearing where the person being accused of selling petrol has said there's something wrong with the car. Now, maybe he was saying that to cover his tracks, but because you're losing that email, we don't know when he started to send that. Then you've got a hard drive which is automatically deleting videos within every 8 days. So you're saying petrol was put on this. All we have is a physical logbook which shows that petrol was put on this day, and on this day petrol was finished. Without the video, without the emails of when he says complaint, you don't have a full case. Their case crumbled just like that. Just like that. Believe it or not. It's so sad. And I've got other stories for you also, which we'll get to as we go through the rest of the questions on the webinar.
That is sad. And then before we get into the 5 ways, I hear that you were talking about a balance of probability or
Yes.
beyond reasonable doubt. So my question is, for corporate evidence, is it beyond reasonable balance of probability? And then in the criminal is the one where you use beyond reasonable
Yes.
doubt.
So differences between civil and criminal. Now, what's the difference between a civil case and a criminal case? A criminal case is one where, number one, there is punishment which is being prescribed by government. There are 4 or 5 punishments which government can prescribe. Number one is the death penalty. I don't know how long that will last. There's big debate now in Botswana about whether the death penalty should remain, and there's debate all over the world regarding whether death penalty is okay. Most countries prefer the second one, imprisonment. Okay, so if there's behavior where either you're going to face the death penalty or imprisonment, most likely dealing with a criminal case. Third type of penalty is a fine. So especially for tax cases, some tax issues, if there's tax evasion and tax avoidance, some of them will attract some criminal liability. And then the other penalty you can have is corporal punishment. Of course, here in Botswana, there is a punishment which we have, which you can get from the quota. Just one short second. Sorry, my IT person is just here.
Okay. If you have any questions, please feel free to drop it on the chat, or you can simply raise your hand and we will open up for you to also engage, or if you have any contribution, we can get.
I'm here. I'm here. Yeah, I'm back. I'm back.
Okay, yes, no problem.
Yes.
Yes, if you
Yes.
can continue, Mr. Mjara.
Let me continue. Let me continue. So, if there are punishments like that, then it's a criminal matter. If you're dealing with a case and the law says that if you do one of these things, you commit an offense. So, in the Income Tax Act, for example, tax avoidance, there's tax avoidance and tax evasion. Okay. One of those is a civil matter. And how will you know it is civil or criminal? If it says if you do this, you will face a fine. Suddenly, you know, oh, this behavior is criminal. Okay. Now, where it is criminal, the amount of proof that you need is beyond reasonable doubt. The state must have proof beyond reasonable doubt. If it doesn't have any of those things, you're facing a civil case. And the amount of proof that's used in a civil case is proof on a balance of probabilities. So it is slightly less proof than a criminal matter. But the problem with corporate evidence is not really whether you're going to be facing a criminal or civil. Do you even have proof to begin with? And that's what our webinar is about. Sometimes if the corporate evidence is being destroyed, you can't even reach the second level, which is on a balance of probabilities. So today we're trying to see how can you preserve, so at least if you have a case, whether it's civil or criminal, at least you have enough, or you have something which you can stand up with. If it's a criminal case, you need to have enough evidence to put doubt in the mind of the court or the mind of the tribunal. If it's a civil case where the risk is that you're going to pay damages to the other side, then you need to have proof to counterbalance the other side. So from the corporate side, that's how your thinking should be. It's a criminal matter. You need to have enough proof to put doubt on the other side. The tribunal should be able to say, I don't think this person was trying not to pay tax. I think genuinely this person wants to pay tax, but maybe wasn't accounting properly. If it's a civil matter, you need to have enough proof so the court can say, no, this person is not liable, shouldn't pay damages.
Okay.
But
sorry, continue. Okay. Thank you for that, Mr. Mjama. So let's look at mistake number one, the IT blunder. Let's look at the major ways evidence is destroyed. If an IT administrator is told to secure a suspect's laptop, what is the biggest mistake they make with the power or the files that instantly ruins the metadata?
all right, this is a very, very important question. Thank you for that. There is a we've already looked at one way in which what we call the IT blunder, where I'm going to give you two. We looked in my example what we call I call it the inbox zero habit. Okay, where you've got someone who really feels that in their emails, the emails must have no unread emails, or they feel that their email is taking space on their computer. Or when they have got a device, okay, so when a new employee comes and they're being given a new laptop or a phone, most likely they're getting a device which has come from a previous employee, right? And what does IT do? IT decides that we need to wipe the device. What are you doing as an IT person if you do that? If you're wiping the device to give it to the new employee, you are taking away not just the files, but the metadata. So, this is a common IT blunder, happens in so many corporations. What should you do? And I hope you are writing this down. if you've got a new employee at the workplace, and you're giving them an employee or a device which was used by the previous employee who has now left the company, before you wipe it or before you do anything of that nature, have one hard drive which you are going to transfer that data to. Make sure you have a record of when that happened. Quickly do an affidavit and say, I'm the IT manager of this company. The data from this device was stored onto this one. What are you doing? You're creating a legal chain, because what is going to be on this hard drive is actually copies. And explain why you were deleting the files which were on the device. Explain that where is this hard drive being kept? So it should be kept in a storeroom somewhere, so that we always have these files. If a case comes up and the other side is saying, no, we were dealing with Mr. So and so, now we've got a chain to show where this device has come. If you're an IT person and you know that emails are used in litigation, can you please kick the habit of what I call the zero email habit? Can you please ditch that habit? There's nothing wrong with emails remaining on there's nothing wrong with keeping old threads. There's nothing wrong with keeping old calendar invites. In fact, myself, because I deal with evidence a lot, even draft messages, which are on an old device, I keep them. I keep them because I never know when a foreseeable lawsuit is going to come. If you have got an auto archive setting on your email, make sure you understand where are these emails being archived. You need to know that. Remove that setting which says delete after 90 days, because it is wiping out evidence. Rather, instead of it automatically deleting or wiping out evidence, it will really help if you do it manually and you keep that item on a hard drive which can be authenticated, where someone can't say later, no, but this was damaged, this was tampered with. This is not the email which I sent. This is not the document which I sent. So the HR or audit trap of trying to delete all threads,
before we go to the
yes,
HR and audit trap,
yes,
I wanted you to expand a little bit on the
on
first
IT
thing,
blunder.
on the IT
Yes,
blunder. You were speaking about when an employee or when the IT person gives a new employee a computer or something of an old employee, and then they delete
yes,
they wipe the computer. And then you say that the IT person must write an affidavit
yes,
that is going to be kept for anything or any rainy day that may happen. Did I get that
yes.
right?
You got that right. And that file should be kept, if possible, in the same room with the storeroom, which we are keeping the hard drive. So that you've got a copy of the hard drive together with the affidavit. Another way, thank you for asking me to expand. Another way, I know a number of big corporations, if they're going to give the device, there's absolutely nothing wrong with removing the actual hard drive which was being used there, store it away, give him a brand new hard drive into the device, if you can do that. And there are other companies which have a different problem. Some of them have got, and this is from an accounting perspective, some companies every 5 years they depreciate the device. Okay, what do I mean by that? So you'll find in most companies they'll give you a laptop. After 5 years, they say, no, the laptop is yours. You can keep it.
Yes.
Yes. And then what happens? The employee maybe finds green pastures. Abata maka Busupi. Busupi is on his laptop.
Uh-huh. Okay. Okay.
Now, Now, how do we solve that problem? Before he leaves, if you're not having cloud cover, remember your cloud cover is if you're having cloud space, that's a secondary, it's a copy of the original. The original is best evidence here. Is the actual laptop which has the information. Nothing wrong with cloud space. Make sure you're the one who, if you're the IT person, you're the one who can do an affidavit and authenticate and say our cloud space is this company. The only person who has access to the cloud space are me and maybe this officer. This is how access to the cloud space is done. And I accessed this document, which I'm now handing up to court in this way. So in both ways, there should be an affidavit recording the chain of what has happened. And if your corporate place is in the habit of, after 5 years, the laptop belongs to the employee, there is nothing wrong in the 4th year or 4.5 years telling the employee, please, can we have the laptop? We want to just remove your movies, remove your videos. Some employees have put WhatsApp on their laptop, and they've got a lot of junk. Some of the videos, adult videos, maybe jokes, adult memes, and things like that. You can tell them, look, we're not going to keep those. We simply want the corporate evidence and the emails. That should go onto, if you don't have cloud space, a specific hard drive, which you keep in a storeroom. If there is a case which comes up afterwards and they're looking for that email, they're looking for that attachment, you have it. And you can say that this email was received on this computer, the employee left, but we always keep a true copy of what was on the laptop. We can authenticate the document. IT officer so-and-so is the one who copied the information onto this hard drive. The hard drive is kept in this room. No one goes in there. He's the one who keeps the key. Boom. The other side cannot say, no, where you getting the document from? You have manufactured this. Now you have not lost the corporate evidence. It's very, very important as an IT officer that you are able to verify whatever exhibit is being brought up to court.
That's very interesting. Now, moving from the IT to the HR or audit track, they rely heavily on email. I know we discussed email a little bit, but
yes,
HR people rely on email as evidence for either policy violation or anything like that. Can you explain why simply forwarding a suspect's email to yourself or printing it out is a massive mistake when it gets to court?
Yes. Now, for those of us who have attended this live, thank you so much for attending the webinar. There is a legal concept. It's very popular, especially in Canada, the US. We do this at the Rankuke Institute. It's called spoliation. And you can look this up on Google. Spoliation. That's SPOLIATION. And if you're searching for it, says spoliation in evidence. There's a same term here in Southern Africa in property law. That's how you get your property back. We're not talking about that. Now, what is spoliation? Spoliation is the tampering of evidence. Now, why are we calling this the HR trap? Most workplaces, it is the HR officer who is involved with investigations. So let's assume, for example, the new buzzword now is bullying at the workplace. There's someone here in Botswana who died recently because of bullying. And if you're an HR person, you will try to investigate the bullying which happened at the workplace. So what are you going to do? You're going to ask other employees maybe to write statements and stuff. And then what you're going to do is also ask the person who has been charged to probably do a statement. And then what you do is you forward. So you want to do your work at home. So you forward that email from your work laptop to your other laptop. We have just discussed the best evidence rule. What are you doing the minute you do that? You are making a copy of the original email, number one. Number two, we don't know what has happened to the attachment when you have forwarded it. Number three, when you forward an email, this is the most crucial point. When you forward an email, try this by yourself. You can actually change the words. Try forwarding an email now and scroll to the email which you are forwarding. Do you know that you can actually change the words which have been sent to you? So by forwarding an email, you are spoliating, you are spoliating the email which has been sent to you. If you forward and then print that forwarded email, we don't know why you're doing that. Are you trying to manipulate the court? You no longer have what was sent. Rather, if you're doing an investigation, rather have this in your policy. In your policy, I still do this, and I know we're going to say that we're going back to the Stone Age, but if it's part of your disciplinary policy, there's nothing wrong with collecting statements. I've got a pen here right next to me because I knew we were going to be talking about this. This is still the best way to collect. Have you wondered why the police, when you are arrested, to this day, they ask you, do you have a statement to say? And then they make you write out your statement. This is 2026 and we're still doing it. Not just here, in Australia, in South Africa. Ever wondered why? Have you ever wondered why, to this day, even at the bank, if you withdraw from the bank across the counter, they've got an electronic place for you to sign? It's because your handwriting is something which is very difficult to forge. Your handwriting is tied to your DNA. How you press the pen, how you do the strokes, all of that, that is unique to you. Of course, it might change depending on your mood, but it's unique to you. Someone can ask, is this your handwriting? We can see. No one can question that. Please, if you're an HR officer and you are watching the recording from this webinar, I strongly urge you, especially in disciplinary processes, collect your statements that you are getting manually. Now, before you forward an email, there's nothing wrong with you opening the email from the other side, and then you read, if there's an attachment, you read the statement, and then you write back and say, I have received the email, and a short statement of what has been said in that email. What are you doing? It's very deliberate if you do that. You are authenticating that which has been sent to you. Now, when it goes to court, the best thing is, of course, to bring your laptop and say, this is the email that I received, and it's not been forwarded, especially with an investigation. This is what was happened. Then the person, your attorney, can say, is this your email? And he's holding your laptop. Is this the email you received? Yes. We show the other side. We show you now bringing best evidence to court. There's no question of tampering of the corporate evidence. Of course, you are allowed to print for yourself and keep in a file. If you do that, you are now creating a backup, secondary backup. But for court, please, especially in your disciplinary procedures, have the original document that has been sent to you. Have the true copy of what has been sent for you. Now, while we are here, let me just raise this one. HR loves to do this in modern time. WhatsApp has changed the way HR works, and a lot of HR companies use WhatsApp Some even have WhatsApp groups. So you'll find there's a WhatsApp group for the management team. You will find that there is a WhatsApp group maybe for the whole staff and things like that. Please, same thing I've said about emails which disappear. If you're going to have that, please don't have disappearing messages. Don't have disappearing messages. Make sure that these messages remain there so that they're preserved, and keep the device, keep the actual device. If you're using a work phone, that device must be kept so that we can authenticate and say, this is the device which receives, it's the corporate one which receives the messages. Turn on, rather, the cloud storage. Pay WhatsApp for that, so that you don't lose any of the evidence. It's a big mistake which HR does. Huge, huge, huge. Make sure that you keep that so that you don't lose any of the best evidence.
The WhatsApp thing that you added there is very crucial, and it's very true, because most companies nowadays find it easy to communicate via those WhatsApp groups or
Yes.
those situations like that. Let's flow to the third thing, which is the physical desk search, right, in the corporate space. When auditing a suspect's physical workspace or documents, where does the chain of custody usually breaks down first?
Okay, now let's explain what you mean by chain of custody and some of the common mistakes. Chain of custody is a term which you will mostly get in criminal matters. Those of you who love to watch movies and stuff, you've probably seen what we're talking about. If someone is arrested, let's say someone has been caught with mutukwane, daha, weed. For those who are international people, mutukwane is the Setswana word for weed, grass, the holy herb, whatever you want to call it. Most of those cases collapse because when the person's arrested, he's been found with a packet of weed. The arresting officer is supposed to put in a bag, tag it, note the bag, note the weight of what has been found. Then there is a storage room for evidence. He's supposed to sign it in. The officer is supposed to sign and say, I have received this bag containing this weight. He weighs it there, and then he countersigns. Then when the bag is taken out and taken to court, the officer who arrested should also be, this is the bag. This is the very bag. Right? Now, all that file now comes with the physical evidence. When the prosecutor is in court, he says, yeah, this is the bag which he was caught up with. And in most cases, the defense guy will jump up and say, how do we know that is the very bag? How do we know? Where is the chain? Where is the chain of custody? Who had the bag from the time of the arrest? Where has it been kept? How did it come to the prosecutor's hands? This is what we're talking about, the physical desk search. So, in the corporate setting, when are you going to do a physical desk search? Most likely, this is when an employee has been suspended from work. Okay, so he's done something and he's been suspended from work. So now you're coming to the desk to see what documents he has there. You're coming to see what he's keeping in his drawer. Now, this is outside of our scope, but tip number one, please, in all of those of you who are in HR, those of you who are in the corporate sphere, please make sure that your company policy has this, maybe in your code of conduct, one of your policies, that all the furniture, all the documents, all the items in the office remain the property of the company, and the company reserves the right to inspect, because the buzzword these days is privacy. People love their privacy. Even in our own constitution, we've got a clause which says that no one will be subjected to a search of his person or property. The way to go around that is in the company policy to say that the furniture, the documents are ours. So technically, we are not searching someone else's property. Now, when you're going to do the desk search before you suspend the employee, there's nothing wrong with him coming and standing there to see what you are putting in the boxes. How do people tamper with corporate evidence? If you're going to pick a file or a paper from the desk, number one, have someone who can verify the list. This is what we have taken. We have found this file. We have found this document. This is the document which has been found. Make a list. Make you the person who is investigating, you sign for that list. Let the employee who you want to suspend or not to, or who you're investigating, to also countersign. This is the document which was taken. Then have a place, if you don't have an ex-employee where you keep your storage, have a place, set place where you're keeping these documents under lock and key. Documents which are going to form part of litigation, documents are going to form part of a court case, should be kept in a specific archival area, ideally under lock and key. Ideally, the person who's keeping these archives should be able to either come to court and testify or swear to an affidavit on how he keeps them safe. And have a good system. Most archivists will be able to tell you that we have three types of files. There's what we call the life cycle of a file. Okay, if it's a live file, or if it is a document which is going around, most offices, let's say a letter comes to the office and the letter needs to be shared. There's nothing wrong with having a rotating box file. Okay, and the officer who's supposed to see it countersigns that he has seen the letter which has been received. What date did he receive it? Who did he give it next to? What does that do? That tells us who was touching the document. That tells us if there was any tampering, where did it happen? Develop a habit of, before the document is going round, have a scanner in the office. I'm saying this again for the third time or fourth time. If your IT person can have good cloud space and verify who is the owner of the cloud, who has access to the cloud, because if a letter is being touched by so many people, or if so many people have access to a particular physical file, what happens? Tea can spill on it. I came with many objects so I can illustrate what I'm talking about. Tea can spill on it. Maybe a drink can spill on it or something. So tampering has already happened with the evidence. So two situations. One is where you're investigating an employee. Let him be there when the evidence is being collected. Have a piece of paper which he also countersigns to say who received the document. Have a safe place where you're keeping it. And if you have documents coming from outside or files which keep rotating, then have a piece of paper where people are signing, I received on this date, this is the state I received the document in, this is how it left. This will help you not to tamper with corporate evidence. I can see a question from Miss Sarafina Gawa, and she's saying, how do we balance employee privacy with corporate monitoring? Oops, the question went. Let me see.
It's right here.
Oh, there we go. Yes. Read it for us, please.
The question says, how do we balance employee privacy with corporate monitoring and evidence prevention? That's the first question. The second question reads, how vulnerable are cloud-based systems to accidental or intentional evidence destruction?
Right. Let's go with the first one. How do we balance employee privacy with corporate monitoring and evidence preservation? The problem is, and I apologize, how do we balance employee privacy with corporate monitoring and evidence preservation? Now let's see if I can understand it. Employee privacy on the one hand. What do you mean by employee privacy. Most workplaces, they have set up cameras in the workplace so that there is no toxicity at the workplace. If you say you're being bullied, if you say maybe you are harassed. So employee privacy, if you've got your personal email, most bosses won't mind you to have that. If you've got your personal phone, which you're using for your personal messages, most bosses won't mind that. And the way in which we balance, if you look at the new Employment and Labor Relations Act, it doesn't allow for bullying and harassment at the workplace. But within an employee and employer relationship, remember the employer has an unequal position vis-a-vis the employee. So at the employer's workplace, the employee has a duty of first confidentiality towards the employer. The employee has a duty to do their work for the employer. The employee has a duty not to do anything which is against the employment place. In other words, the right to privacy of the employee is more or less reduced. When you get to the employment-employee relationship, the employer actually is going to invade more or less a lot of your space. So if you're trying to keep something private, don't keep it at the workplace. Don't keep, for example, if you want to use at home, you can watch whatever you want. If you want to watch adult content you want, don't do that at the workplace and then try and hide behind employee privacy. Now, for evidence preservation, unfortunately, in an employment relationship, the employer has every right to keep whatever forms of exhibits that he has about you. So when you talk about employee privacy, the only limits that you have are those that you have in law. The employer shouldn't subject you to a search of your person without a warrant. The employer shouldn't harass you at the workplace. But the employer, because the relationship legally, can ask you to submit a document he has. And if their policy, like I said, says that any document belongs to the company, whatever you produce belongs to the company, then in actual fact, they have the right to do a search at your desk. I know it's not a satisfactory answer, but if you are a good employee and you're not doing misconduct, then most likely they won't search you. There shouldn't be any problem. Now, second question. How vulnerable are cloud-based systems to accidental or intentional evidence destruction? It depends on which cloud-based system you are used, which one you are using. Some of the free ones, of course, hackers can get in at any time. So it's important you as the IT specialist to suggest to your employer, let's get this one, of course it's now down to finance, to get this one which there is more security. Of course, hackers are getting more and more smart, are getting more and more clever. One way, of course, of limiting the evidence destruction is to limit the people who have access to it. So best companies, best practice, only the IT officials are the ones who have specific passwords to the cloud-based. If it is general information, that one can be kept on the intranet, no problem. But if it is information which is being kept, especially with litigation in mind, only the IT person and the MD should have access to it. Secondly, get a cloud system which can print out for you who had access to the system and when and for how long, what file did they access, how did they edit that file. So it's not about how safe they are, but it's about get a cloud system which can give you printouts of access to that information. So that even if a hacker comes in, we can see, oh, the cloud was hacked at this stage, at this time. That is the important part that we have. The best cloud-based systems are getting more and more secure by the day. But like I said, we cannot give 100% safety. I'm sure even Donald Trump, there's one stage he was accusing China of getting into the White House systems. In his first presidency, there was a lot of accusations of Russia tampering with the evidence regarding the elections and the nominations for the Republican Party. So, how safe? It's not 100%. However, if you've got a cloud system which can give you the information of who accessed and when, then that is much, 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 much better. And let's face it, for most businesses, what they're looking for is money. We are not at that stage where in Africa where we have corporate cloning or malicious hacking. So for most companies, please, 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 if you can have that secondary evidence, I still highly recommend cloud-based systems.
All right. Thank you. Thank you for the question, and thank you, Mr. Mjama, for answering the question. If anybody has any other question, kindly raise your hand or just drop it in the chat. We'll definitely get to the question. Now, mistake number 4, Mr. Mjama, it's a premature interview. You know, in the corporate space, normally when there's a disciplinary hearing or anything of that sort, they like to have bring the suspect, for lack of a better term, for an interview so that they can conduct the interview. Is there anywhere where the preliminary interview can jeopardize digital evidence?
Yes, there is. Before I'm going to forget this one. If this other point I was going to make before we get into that, another mistake which HR people make, and this is very, very common. If this is you, you'll probably say yes, I'm guilty of this. A lot of HR personnel or even the library or archive people of a company, there'll be one day where they say, hey, we need to clean up this place. We need to do spring cleaning. We need to put these files away. And suddenly, they'll say old files, all these old files, we are burning them, we are discarding them. Please, you are ISO 2001 compliant. Can you please comply with the ISO rules? Okay. ISO will give you guidelines of how old a file should be before it is destroyed or sent away. And if you're going to spring clean the area where you are keeping your files, again, coming back to cloud system, absolutely. If let's say there are files that are 10 years old, 15 years old, remember in Botswana, for criminal cases, they don't expire until 20 years have passed. So if the files are relating to anything where potentially there will be criminal activity, we still strongly advise here at Rankuke, you need to have at least a digital copy for the next 20 years. Wonderful question from Tapelo Taps says, who is responsible for my data security on those cloud-based storages? And what is the correct procedure when dealing with data breach for that moment? Oof, now we're going out of the legal sphere into the computer-based area. I'll do my best with the caveat that I'm a legal expert, not a computer expert. Now, let's see, who's responsible for my data security on those cloud-based storages? Double-edged sword. Let's take Google Mail, for example. You have full access to your email with your password. You can delete it. You can forward it. to that degree, you are the owner and responsible for it. That is not to say that Google itself can't delete it from their side. If you've got a data breach where you can see someone has hacked your information, immediately it helps if you close the system, try and find out what has been breached. Legally, you should keep a record of when that happened, a record of which files you can see from the metadata have been potentially been tampered with. Make sure you've got an IT officer who is aware with IT security. He'll probably know more of the technical procedures of what to do if there's been a breach of that data, if it is cloud-based. Let's bring it to the physical side. What do you do if your original files, not computer-based files, let's say there's been a break-in, let's say there's been a fire, whatever it is, but break-in especially, someone has come to take in your original files. When you do come to court, you need to have testimony, best testimony of what happened on that date. You need to be able to explain why you're not able to bring the original that you had. You need to be able to explain what steps you took so you can have, so that you could have had the original. How did you make that copy? Is it a copy of a copy of a copy? What have you done to ensure that the copy that you're coming with to court is as close as possible to the original? Who verified that this is not been tampered with? So I think Tepelo, you are coming at in the middle of the webinar. There's one stamp which I was recommending everyone to have. That is a stamp which simply says, this is the annexure referred to in the affidavit, or even true copy. True copy. Okay, so, and have the officer who is making those copies be able to tell the court, I'm the one who made the copy. I'm the one who made the copy. I saw the original. I'm the custodian of the files. Okay, it's not a complete answer, but it is the best we can give.
I agree. I don't know if you had wrapped up the.
No, I'm now getting into it. The story, the question which you had given, maybe you can ask it again. I believe the premature interview question. So what do you do?
Tapelo says it's a good answer. So the question that I had about the premature interview was based on, when HR and or audit are doing the disciplinary hearing and they are inviting the suspect, for lack of a better word. And that interview, can it actually jeopardize with either the digital evidence or anything of that sort?
Okay, there we go. Now, first, what do we mean by premature interview? There are 3 mistakes that HR personnel make, and they are destroying corporate evidence. Now, it's possible that you're making this mistake. Number 1, during an investigation for disciplinary hearings, if you are going to alert the suspect before you have collected your evidence, if they're aware that they are under investigation, what are they going to do? You know that they're the suspect. They're going to go and destroy whatever document they have. They're going to go and tamper with whatever we have. So a premature interview, let's define a premature interview. A premature interview is where you are interviewing someone who is suspect without you, the interviewer, having all the facts on the table. Make sure you yourself, you have the facts on the table before you call them in. So let's say, for example, there is we'll take bullying or harassment again as our running example. So one employee is saying that I was harassed at work by so and so. Try and collect that statement from the person who is the victim. Try and go to your video footage. Go and run the video footage and see who was in there. What happened there? Ask the victim, what date did this incident happen? Go to that date. You yourself. Go and edit it. Edit the part where you can see the incident which is talked about. Save that. Make sure the guy who handles your security system for the video is doing a quick affidavit for you, so they can say that, yes, this is the video, the editing was done by me. Now you can call the accused and say, Munna, you are accused of harassing so and so. We have a video of you. This is the video. This is the date. You can see the timestamp on the thing. What do you have to say? If you call him before, nothing stops him from going to where the recording is, starting a fire, or whatever it is. Nothing stops him from trying to hack into your system where you're keeping the videos. So, when we talk about premature interview, this is compromised where someone, the person who is being interviewed, has an opportunity to go and look at the evidence and begin to tamper with it and begin to change it. So, if you're going to investigate someone, and these days, let's face it, most corporate areas, everything is on email. Almost everything is on email. Almost everything is if it's the payroll, is on Sage or whatever it is. Do not do even the show cause letter until you have all the information that you have, because the suspect themselves are the ones who are going to tamper. If possible, suspend them and close their access to your network. When the investigation is over, you can say, yes, you have the right to prepare for your defense to a disciplinary hearing. We will give you limited access on this day, and let the IT personnel be present when they are getting their evidence for their defense. Let the IT personnel be present to see what file they accessed and when, what did they do with that file. Otherwise, you are going to have a botched disciplinary hearing where your evidence was tampered by the suspect themselves. Back to you, Mr. Rangwaile.
I can promise you, Mr. Mjama, this makes total sense in my mind. I mean, if a suspect is just being told that we're disciplining you and then just left there, they're going to probably do something to that evidence. And this is really eye-opening. But anyway, the last one, the fifth way, the storage nightmare. We spoke at length about storages, but I just want to wrap it up with this question that once a device or a document is actually seized, what are companies getting wrong about how they store or transport it? What happens what happens if I just, take that confiscated phone and I just toss it in my desk drawer and then call it a day?
Do you even? There are so many things which people get wrong. Where is it being kept? Who took it? You're putting it in a desk drawer. Is that a lockable drawer? Who has access to that drawer? And it's very interesting. I told you I've got stories about this. One of these things I saw was actually at a university where I used to work, and this student was found copying in an exam. These days, students are very, very interesting. They come with devices to the exam room. This student had a cell phone, and I think communicating with someone outside So over WhatsApp, messages were coming in. So the invigilator comes, grabs the phone, attempted to switch it off, and just took the phone and put it in their drawer. Now, unfortunately, this student was government sponsored. So if you're going to suspend them, government needs to know. Okay, and they need proper minutes of what has happened. It was a nightmare, I can tell you, a nightmare. This lecturer, unfortunately, it was an iPhone. This lecturer could not explain why the phone was being switched on and off. The person had tracking. So number one, what if the device has tracking of when you switch it on and off? Why not let the owner of the device switch it on in your presence before you put it in the drawer? Why not remove the battery, if it's possible, you've got an external battery of it? Why don't you take the serial number of the phone? So at least, number one, we know which phone is being kept. He should know, the owner of the device, where is this device being kept? Is it very, very hot where it's being kept? If it's a place which has extreme heat, it's going to destroy the device. And he will say the file is corrupt because it was in heat, and you're going to lose the evidence because you've not stored it in a cool, dry place. It's a dry place. Why don't we have the person who is keeping the phone? He needs to keep an affidavit. He needs to have a proper chain. Let him sign and say the device is kept in my custody here under lock and key. I'm the only person who has access to it. Or if it's a safe, the only person who has access to it. The keys are kept with me at all times. Or the keys are kept at this place at all times. If you've got a security company, have that security officer sign that affidavit. How do we know no one has touched the device? What are the procedures you have for keeping such items which have been confiscated? Do you have a policy at the workplace for confiscated items? These are some of the big mistakes which most companies make, and then they wonder why, when the matter comes to court, it is not acceptable, or the thing is not admitted into evidence. So if you've not heard anything or understood anything from this webinar, please, a lot of the problems we're discussing today are policy problems. You need to have the correct policies and procedures at the workplace. In writing, you need to educate your employees that if, let's say you're a supervisor and you've got your junior employee making a mistake, your supervisors must be trained. How do we do it at the workplace? And perhaps you should consider doing a course at Rankuked. Come and do one of our courses where, instead of the webinar setting, we go through a lot of these topics in much depth. I think we're the leading fraud institution. Not that we teach people how to do fraud, but fraud training institution in Botswana.
Okay, thank you very much for that, Mr. Mjama. So let me tap into your legal expertise a little bit.
Yes.
So let's say a company has done all these 5 mistakes, right? The IT did not write an affidavit when they were storing data. The HR did not, they forwarded themselves their email. They didn't secure the physical desk. They didn't do the proper chain of custody. They did the preliminary interview, and they didn't store the smartphone properly. Now, using your expertise, if the defense attorney gets a hold of that type of internal investigation with those mistakes, how brutal is the cross-examination? What can you say there?
Oh. Now, here we go. Now, what happens? Our court systems, especially the Commonwealth countries, are what we call adversarial court systems. If you go to Italy, France, they've got what they call inquisitorial systems. Now, inquisitorial systems, from the beginning of the incident, a prosecutor is assigned. and the court, the magistrate is already assigned. The magistrate is part of the investigative process. So if you're in France or Italy, you're okay. Your magistrate is probably going to get this training. If you're in Botswana, South Africa, America, Australia, UK, what we call common law countries, we have an adversarial system. And that means that the judge sits like a referee. It is the lawyers who are coming to court who are determining what evidence comes. If you've made these 5 mistakes, either one of them, the attorney or advocate on the other side is going to challenge the authenticity of the evidence you're bringing to court. They're going to fight tooth and nail and say, please, judge, don't admit this evidence as an exhibit. Don't let it in. It's wrong. It's not the best evidence. We doubt it. And so there's a very big risk of you losing a case, not because you didn't have a solid case, but because you went and destroyed the corporate evidence. So we have a structured methodology in our CFI program, CFIP program. And we want you not to make any accidents. We want you that when you've got a clear case, I started off with the story of the Hansi case. Now, if that company was storing the videos, if there's any incident, making sure that the security guy has gone through some of this training, so that if there's any incident, that clip is stored in a particular way. There's an affidavit to authenticate it, so it can be admitted into court. That clip is stored in a specific, so no, the lawyer can't come to court and say, no, you have created that video, you've used Chat GPT. Like I said, I'm not an IT expert. Apparently, you can make a video of me doing anything. I don't know how true that is. But if you've got that authentication, now they could have won that case of the employee who was, as far as I'm concerned, was stealing petrol. And he got away on technicalities of evidence. Very, very sad.
That's very, very sad. Last question from me. Last question from myself. If an HR manager, right, or an IT administrator suspects something wrong or something may have happened, what is the first non-negotiable step they must take to ensure they don't taint the scene or the evidence? That's what would you advise?
Don't touch. Don't touch. If something has been, let's say you're doing a desk search and you think something has happened, don't touch. Take a record of the scene the way it looks now. What you're creating already there is best evidence of whatever has been found there. Then make a record. It's all about record keeping. Make a record of what you've seen there. Make a record of what it was before. If there's a video in the corporate place, make sure you access it quickly so you can say, I first came, I think the place was tampered. I then went to other circumstantial evidence to see if there had been tampering. This is what I found. Do it immediately. Don't wait, because now questions will come. Why did you take too long to record? Do that as soon as you got there, and you will be believed in the courtroom.
All right, that was all my questions. I'm opening up for anybody who wants to ask a question, have a contribution. Kindly just raise your hand or drop the question on the chat so that we can get to it. Feel free to ask the question.
I think they're shy.
Okay.
But they've been, to be fair, they've been very, in fact, I'd like to thank all people who have attended. I can see your questions. We've been going through them on the chat box. So thank you so much for those who participated.
Okay, right. In the absence of any questions, contributions, I would like to first of all thank each and every single individual that made time to join us on the webinar. I have written my email, which is marketing@rankuke.com on the chat, so that anybody or if anybody who wants those CPD points, we can easily facilitate that. Just drop me an email and then we can attend to that. And then secondly, I would really, really like to thank you, Mr. Mjana, for your expertise, for your patience, and for your understanding, and also for answering all questions that we had, and also parting ways with your knowledge so that we can benefit. I promise you, I learned a lot, balance of probabilities, beyond reasonable doubt, and the separation of the two annexures, exhibits. It was really an informative webinar. And if you want to see Mr. Mjama and the likes of Mr. Mjama, he said it a little bit earlier. We do have a program called Certified Forensic Investigation Professional, which is a
There we
6-month
go.
course that you can join, and then you can expand on these situations in a structured way that can help you understand this thing called evidence or forensic. I don't know, Mr. Mzama, do you have the last words before I close?
I think we've said it all. Let's come. You promised some points to those who attend. I don't know how they're going to get their points. Maybe they can know more about that. But there are going to be more webinars coming up. Looking forward to seeing you and also some other new faces next time.
Yes, thank you. CPD points are going to be issued